At common law, the validity of a restraint on trade turned on whether it was reasonable or unreasonable. In United States v. Trans-Missouri Freight Association, the Supreme Court was called upon to determine whether the same distinction applied under the newly adopted Sherman Antitrust Act of 1890. In the second half of the 19th century, it was common practice for railway companies to enter private agreements regulating competition. In 1887, concerned about negative impacts on public interests, Congress passed the Interstate Commerce Act, or ICA, which prohibited railroad pooling agreements, a form of profit sharing, and required that railroad charges be reasonable. But the ICA didn't expressly prohibit agreements to fix reasonable rates. Consequently, in 1889, 18 railway companies operating across the western United States formed an association known as the Trans-Missouri Freight Association to establish and maintain reasonable rates for all freight traffic on members' lines. But the next year, Congress passed the Sherman Antitrust Act of 1890, which declared contracts in restraint of interstate commerce illegal. The United States government subsequently sued the Freight Association for violating the Sherman Act. The railways countered that the act didn't apply to the railroad industry, which was already governed by the ICA. Alternatively, they argued that the Sherman Act prohibited only unreasonable restraints on trade, and consequently, their agreement establishing reasonable rates wasn't a violation. They claimed that without such rate-fixing agreements, the fierce competition between railroads would result in race-to-the-bottom pricing that would ultimately lead to the industry's downfall. The United States Circuit Court for the District of Kansas, as the federal trial court was then known, dismissed the government's claim, and the Eighth Circuit affirmed. The government appealed to the United States Supreme Court.